make that good when I deal with the Section 7 submissions that I have.
So let's go to your aid memoir then.
Yes. Because I'm in my aid memoir, paragraph 2. Because your Lordships may come straight away to paragraph 3. What I'll tell your Lordships how I've structured the aid. I have an introduction of 7 paragraphs where I set out the background that your Lordships should bear in mind while considering this case. Then I have 6 different heads of submissions and I'll run through them as fast as I can. Look, paragraph 3 of my aid. Look, there are, in my respectful submission, 3 fundamental facets which form the background consideration. Look, the first fundamental facet, and I think this is absolutely well accepted under Indian law, as it is under other laws, is the doctrine of separability. And that is, in my respectful submission, fundamental to the consideration, because it is the doctrine of separability which looks at the validity and enforceability of an arbitration agreement. And why that becomes important is that there are lots of passages, I take a lot of Chloro and other decisions, which talk about the performance of a contract and obligations that a party may have undertaken under it. But today what your Lordships is looking at is in relation to a non-signatory and performance under a separate doctrine, which is a separate arbitration agreement. There may be rights that you may exercise where you commence an arbitration. If somebody initiates an arbitration against you and says, sorry, you are bound by an arbitration agreement, you are obliged to arbitrate our dispute, you can't go and file proceedings in court or do something else. Look, that is fundamental in my respectful submission when your Lordship is considering this case, because performance has to be judged from the performance of rights and obligations under an arbitration. The second aspect, which is extremely relevant for your Lordship's consideration, is India's acceptance of the localized theory of arbitration. Now, if your Lordships recollect, in Bharatiya International, we diluted that principle. We went a little step ahead and we said it doesn't matter the seat of arbitration is something global. Paragraph 88 of Balco, where the first U-turn came to become an open said in our opinion, and he was looking at section 2, the authority does not relax the territorial principle adopted by the Arbitration Act 1996. It certainly does not introduce the concept of delocalized arbitrations into the Arbitration Act 1996. Now, the reason why that is critical, Malone, is this. France, as your Lordships is aware, does not follow the localized approach, and Dow originates from France. France follows the transnational. On the other hand, that's one further reason why your Lordships as well, Singapore does, is because Singapore and England follow the localized approach. Singapore is a model law country, because I have, in fact, in my footnote, and the decision is there before my lords, there's a decision called PT First Maintenance, the 2013 decision of Justice Sundaresh Menon, when he just, in fact, recently been elevated and become Chief Justice. And in that case, he has very categorically set out that Singapore followed the localized regime. The reason why that is relevant is because there is a national law which governs the conduct of arbitrations, unlike France, where it doesn't matter. And for the French aspect in relation to this, can I just draw your Lordship's attention? Your Lordships needn't open this right now because it's all there. You can, Lordships could just mark this, page 1171 of my edition, which has the article from Bernard.
Why don't we read your note? Then we can maybe go through some of your documents and
I certainly will also do that.
How long is your note?
It's a 15-page note.
Let's run through the notes so that we get the whole bearing. Get a picture of and then we can go through, I'll touch upon the judgment, etc.
I'll absolutely do that. The reason why I made that, why I was just making a reference to Hanisha, because Hanisha draws that comparison at page 117.
So let's go to para 5 now.
Yes, can I just make 2 or 3 points just before I get to para 5? I'll just run through the note. The third doctrine is, we've accepted that contracts are certain and terms must be read as such. Now, why the adequate public policy? Because your Lordship is considering a doctrinal approach, and there's no difficulty with that. One, we want to be considered as a hub for arbitration. 2, and this is slightly critical. Awards which are made in India need to be enforced outside of India. So, your Lordships wouldn't want to be in a position, and I made that good paragraph.
So let us read on this. Just read the note actually.
I'll just. So, This backdrop, paragraph becomes essential when considering India's avowed legislative policy to one, be considered as a hub for arbitration, two, to ensure that awards which are made in India would be enforceable outside of India in terms of the New York Convention, with the Articles 2.1 and 2.2, and enforce awards in India which are consistent with the New York Convention, which your lordships will have bear in mind, Section 44 of the Arbitration Act. Because this decision will go across all these three paragraphs. These principles must drive, in my respectful submission, the interpretation of Section 7 of the Arbitration and Conciliation Act, insofar as ascertaining whether an arbitration agreement can be extended to non-signatories, as well as appreciating the doctrine of claiming through and under as set out under Sections 8 and 45. I'm sorry, I'll just take a 20-second digression. Imagine a scenario where a suit is filed in India, and the court under Section 45 refers the matter to arbitration, which is say in London or Singapore. And they turn around and say, sorry, under our law, we cannot start arbitration against a non-signatory. Because jurisdiction will be the law of the seat. So therefore, if an application is which I've dealt with later, it's in fact, in my respectful submission, a defendant's doctrine. If such an application gets filed, how does the court proceed? Does it just send everything to arbitration? Person goes to Singapore, then comes all the way back and says, sorry, I can't do anything. Suits anyway gone. Arbitration is gone. Time is spent. Now let's paragraph 6. Bearing that, it is respectfully submitted that as a seat, India cannot be overzealous to extend the jurisdiction of arbitral tribunals to non-signatories who may simply be a part of a group of companies. 2. Courts applying Indian law also ought not refer parties to arbitration, whether domestic or international, on an expanded interpretation of claiming through and under. And tribunals also ought not put themselves in a position where, as it transpired in Dala real estate, an award is passed in the seat court and is held not to be enforceable by an enforcement court because different principles will also have been adopted. And why this is again extremely important is what I've said at paragraph 7, because your lordships is dealing with the question of jurisdiction. It is imperative to bear this in mind that since this issue touches upon the jurisdiction of arbitral tribunals, any interpretation by this honorable court ought to be consistent with internationally accepted principles for joining a non-signatory to an arbitration. That is because the issue of jurisdiction is considered de novo by the court, whether it be the setting aside or the enforcement. This has been set out by the Singapore Court of Appeal and PT First Media, where the court stated that jurisprudence of the Singapore Court has also evinced the exercise of de novo judicial review. The Singapore International Commercial Court, this is in fact Sir Bernard Eder in CPU, where he stated a challenge to the tribunal's jurisdiction should be heard by way of a de novo hearing, as well as Dala, where at the enforcement stage, what the court said is, our view that an arbitral tribunal's own view on its jurisdiction has no legal or evidentiary basis, and a party who has not submitted to the arbitrator's jurisdiction is entitled to a full judicial review on evidence of an issue of jurisdiction before the English court. So my suggestion, and as I'll make that good, is going to be this. If we overexpand this doctrine, even if I have an Indian seated international commercial arbitration, and the arbitral tribunal proceeds against a non-signatory, when I go out to enforce that award and there's a de novo review of jurisdiction by countries which follow the localized regime, maybe not in France, but a significant number of countries under the New York Convention follow the localized regime, the unilateral. That award is susceptible not to be enforced on the ground that there is lack of jurisdiction. Whatever interpretation that your lordships sets out today transcends three spheres. The sphere of the tribunal's jurisdiction, the sphere of enforcing awards outside of India, and take the case, say, of an Indian company, an Indian parent, a big place, say, taking sugar from UP, exporting it outside. It takes the call. It says, I'm setting up a subsidiary in Singapore, I'm setting up a subsidiary in the BVI, I'm setting up a subsidiary in Cayman Islands. It's fully entitled to that. That BVI company and the Cayman Island company enters into a contract with a Chinese company or Hong Kong company or whatever. There is a dispute. That arbitration award is passed against the BVI company or the Singapore company. Let's assume the Singapore company is a $2 company, but the Chinese or the Hong Kong company perfectly with its eyes wide open says, I will enter into a contract with a $2 company and I will, at the end of the day, have my dispute with the $2 company. Dispute is fought, dispute is lost. Can you enforce it against the Indian company in India? In my respectful submission, the answer is no, you can't. Because with open eyes, you, the foreign company, contracted with my foreign subsidiary. Now you fight it there. That's why Section 44 will become critical. New York Convention Articles 2, 1 and 2 will become critical because this interpretation that your lordships give, they will run across all these three. Tribunal's jurisdiction 2, 1 and 2, 2 and 44 of the arbitration.
Mr. Diwan, you are talking about enforceability. That's the emphasis now.
It's
also, but
yes,
you see, just by applying the doctrine, we are not saying a non-signatory is being brought in. We have to also look at his intent, his conduct. Those are the parameters on the basis of which we'll apply the doctrine. I mean, just because the doctrine is, we adopt that this is a doctrine to be followed, it doesn't mean that we bring in non-signatory without looking into their intent and conduct.
Your Lordship is absolutely right. And which is why, my Lord, one of my submissions where I point out to certain paragraphs in Chloro and Cheran and MTNL, which, my Lord, I'll tell your Lordships from practical experience, because we use all these judgments very often, my Lord, in international commercial arbitrations to either bring in a non-signatory or to try and move away from an arbitration, are used in a manner which, in my view, overexpand the jurisdiction of the tribunal. And since your Lordships is sitting in 5 today, in fact, one of my submissions is going to be that your Lordship should either clarify those parts or set aside or strike out certain parts of those decisions, so that it cannot just be a group of companies or single economic entity and nothing. It cannot.
It can't be nothing.
That's right. But there are parts of all of these judgments which are cited often enough, which become a
That, I mean, that's what lawyers' ingenuity is something which you cannot ever curb.
Since your Lordships is giving clarity today, and I made that good, and I'll take your Lordship.
That's only a great aspiration that, judges can give clarity which will last for all times to come.
But certainly,
it's as good as the next lawyer with an imaginative mind.
Yes. But certainly your Lordships, in my respectful submission sitting here, should look at this aspect, which I think is important, because it has significant ramifications. And that's really the point I wish.
You seem to be suggesting that the omnibus expression of group of companies is not very precise. So go into expressions such as consent and other things is what you are.
Mutual intent.
Mutual intent.
Yes, please don't go by just the economic entity being the same.
It's like that, which have generally been.
In fact, for the rest, I have suggested that your Lordships was.
So concrete suggestions as you suggest, Mr.
Yes, because in fact, I set out at paragraph 27 and I'll come there. Let me just quickly run through paragraph 8. The very foundation of arbitration is
all consent.
In fact, we had this book, there's an entire Oxford University Press book on consent in international arbitration. We put this version of it here. It's not, I don't have it here. It says the principal characteristics of arbitration is that it's chosen by the parties by concluding an agreement to arbitrate. The arbitration agreement is considered the foundation stone of international commercial arbitration, as it records the mutual consent of parties to submit to arbitration, mutual consent which is indispensable to any process of outside international courts. Such processes depend on the agreement of the parties. Hence, this element of mutual consent is essential, as without it, there can be no valid arbitration. Under Indian law, such consent is typically required to be expressly set out in writing by means of an arbitration agreement, and that's a standard signatory rules doctrine. Now, my first submission is this: the group of companies doctrine and the single economic whole legal form, and cannot be the basis for imputing consent. It is respectfully submitted that the GOC doctrine has no legal form. As set out in paragraph 8, these are my first skeleton submission. The GOC doctrine is a purely economic concept, which has no basis in either contract or company law. It runs counter to the principle of separate legal personality for companies. And this decision that I have cited, which is the Bank of Tokyo, in fact, it's Lord Gough's decision, whereas Lord Hoffman, then a lawyer, was arguing. And interestingly, your lordship will find the same quote even in Mr. Kambata's submission. We just happened to have extracted it at the same time, where he says, Mr. Hoffman suggested willingly that it would be technical for us to distinguish between parent and subsidiary companies in this context. Economically, he said, they were one. But we are concerned not with economics, but with law. The distinction between the two is, in law, fundamental and cannot be breached. And also that same book that we have, which is Consent in International Arbitration, what they have set out is this. The group of companies doctrine is probably the most prominent and controversial of the theories developed to extend an arbitration clause to non-signatory parties. Unlike other bases for binding non-signatory parties to an arbitration agreement, such as agency, alter ego, estoppel, which have their origin in contract law or company law, the group of companies doctrine was developed specifically in the arbitration concept. The treaty is also carefully analyzed various countries and compares the acceptance or lack thereof. My Lord Justice Narasimha, in fact, put that question yesterday. Is there a comparison? Lord, in this treatise, there is a comparison. Lord, it is part of the bundle of authorities that I have cited. Your Lordship notes can look at it. It deals with France, Switzerland, England, and the United States. And let's talk about how and when it gets accepted. Now, the rejection of the doctrine as a basis to extend the jurisdiction of an arbitrary tribunal over a non-signatory in Peterson Farm was also relied upon by the Singapore High Court and Maharashtra Steel at paragraph 75. Now, paragraphs 12, 13, and 14. I have extracted from the Singapore High Court's decision in Maharashtra Steel. But can I just take your lordship through that decision?
We'll go through this and then we'll go through the decisions.
Certainly. Yes. So, the rejection of the GOC doctrine as a basis to extend the jurisdiction of an arbitral tribunal over a non-signatory in Peterson Farms was also relied upon by the Singapore High Court in Maharashtra Steel, which at paragraph 75 observed that for now the import of Peterson Farms was that as a matter of arbitration principle, a tribunal has no jurisdiction to bind strangers to the arbitration agreement on the basis that these strangers are part of a large group under the group of companies doctrine. This was yet another example of how stringently the courts regarded consent to arbitration. Similarly, even the single economic entity doctrine has no legal form. In Maharashtra Steel, the Singapore High Court rejected the argument that a single economic entity concept is recognized either under common law or under Singapore law. In fact, observed paragraph 92 that because the law allows and treats a company as a separate entity from its shareholders in the ordinary circumstances, it is perfectly acceptable in many jurisdictions, including Singapore, for an enterprise to be established and carry on business as a BVI company with the attendant advantages of non-transparency of ownership, management, and financial positions. Generally, a BVI company need not make public details of its shareholders, directors, or financial statements. That the shareholders of a BVI company are unknown or may not be identified through public means is not relevant as to whether a BVI company has capacity to enter into legal relations. Its capacity is derived not from its shareholders' legal personality, but from its separate and distinct corporate legal personality. Why any business person would choose to contract with or accept the credit risk of a BVI company without extracting a personal guarantee or some security is, of course, a separate matter. It has also been said under paragraph 96 that plainly the law eschews disregard of the separate corporate legal personality of a company except in exceptional circumstances and only where there has been some form of abuse. Respect for separate corporate legal personality of a company with the rights and liabilities attached to that personality is sacrosanct in nearly every other circumstance. So, when your lordship lifts a corporate veil, etc., those are different circumstances. Otherwise, separate legal personality is accepted, and if you've chosen to transact with the BVI company, then you've chosen to transact with the BVI company. And if your arbitration clauses with the BVI company or a Cayman Island company, then that's what you as a counterparty have chosen. Nobody is stopping you from going to court, which is the Section 28 argument which Mr. Kambata had raised. And we fully subscribe to that. But if your arbitration agreement is with the BVI company, and that's a separate legal personality, then that's where it stands, unless, of course, the other grounds are made out to bring a non-signatory in. Since neither the GOC doctrine nor the single economic entity doctrine can be recognized as ones having any legal form, they cannot be demonstrative of establishing any intent of a non-signatory to arbitration. So that's my broad basis. Now, as I come to the facets where I think where chloro, Cheran, MTNL, and ONGC, my respective submission should be clarified, or I've said it. Let's just first look at paragraph 103, chloro, which sets out two basic, I would say, the basis by which you can bring a non-signatory. 103. Various legal bases may be applied to bind non-signatory to an arbitration. 103.1. The first theory is that of implied consent, the party beneficiaries, guarantors, and other mechanisms. This theory relies on the discernible intention and to a large extent on good faith principles. They apply to private as well as public entities. The second theory includes the legal doctrine of relations, apparent authority, piercing of the veil, joint venture relations, succession, and estoppel. They do not rely on the party's intention, but rather on the force of applicable law. While there is no concern with respect to 103.2 of the law, where a legal basis is adopted to ascertain which is the real party to the dispute, to the extent that paragraph 103.1 seeks to bind a non-signatory to an arbitration agreement, and to a large extent based on good faith principles, it should be clarified that unless a court or a tribunal finds there to exist a discernible intention to arbitrate, a non-signatory should not be compelled to arbitrate. So, if your lordship just strikes that red part out, and it is that you must find a discernible intent.
You don't sort of read a passage in a judgment and then, identify, some portion. You read the whole passage together.
Look, I said, your lordship, so the problem.
Therefore, once we accept that mutual intent or consent are the key factors, how does consent or mutual intent get deduced? That's the point. Then to decide whether there was consent or whether there was a mutual intent, obviously you'll have to look at various factors.
How do you?
And those factors cannot be decided with any specificity in advance.
And I'm not for a moment suggesting that. Please don't take it.
So therefore, you also accept that, mutual intent to arbitrate, consent to arbitrate, these are key because of party autonomy, because of the doctrine of severability, so on and so forth. Once we accept that, then in isolated observations and chloro control, you're right, it may require a little bit of tightening up. But we can't just say, okay, they read these observations in red and therefore don't read the observations in black, which are not highlighted. Everything reads together ultimately.
I tell your lordship for the difficulty. When I have no difficulty with the broad aspect that your lordship said. Chloro needs tightening up. And
there's no difficulty once these observations are in the hands of seasoned arbitrators. They know where to apply the law. They know what to. They don't read the judgment as a sort of, as something written in stone.
I have 5 examples, and these are, in fact, Mr. Kambata and I, in many cases, been on the same side and been on the opposite side. I've been on sides where I have propagated a slightly overbroad approach. And these are real life examples of international.
That's the fun of lawyering, right?
That's right. But the fun of certainty.
You can never have certainty. The quest for certainty is
having certainty.
Yeah.
What I am requesting my lord to take this matter is bringing up.
Mr. Diwan, this point is very well taken, that consent is an essential part of it. But have you suggested that how to tighten it up? What are the factors which the court must take into account to decipher whether there is actual consent or not?
Yes. I will deal with that. That's a paragraph 27. It's a short, there is in fact a numerical decision, and I would
tell us
also come to dialogue. But can I just point out a few other paragraphs here which are really turning out to be the problem? Look, your lordship will look at reconciling paragraph 71 to 73 and saying, of chloro, and saying, let's read it all together. But Willows, I can tell your lordships often enough that 73 is read as a silent paragraph. And in my respectful submission, the way it also was founded in Cheran, seemed to suggest that what was accepted was a 73 was a 7. And 73, in my respectful submission, is the problem, because what 73 says is as follows. A non-signatory or a third party could be subject to arbitration without their prior consent, but this would only be an exceptional case. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of subject matter, and the agreement between the parties being a composite transaction. So three facets which can be used to say, well, without consent, we can bring you in. The transaction should be of a composite nature where performance of the mother agreement may not be feasible without aid, execution, and performance of the supplementary or ancillary agreement for achieving the common object and collectively having bearing on the dispute. Besides all this, the court would have to examine whether a composite reference of such parties would serve the ends of justice. Now let's please see how under these three facets it becomes so overbroad. One, the first three, which is relationship, commonality of subject matter, and composite transaction have nothing to do with intention, standing by themselves. Two, performance. And there, paragraph 76 becomes a bigger problem. And three, does it serve the ends of justice? You may well take that view when your lordship is sending a party, when your lordship is sitting in court. But when it's an arbitration agreement and someone hasn't signed it, and you haven't chosen an institution which allows for consolidation or joinder, when you're sitting ad hoc, can you just bring in a party? Because if I say take the ICC rules, or if I take the SIAC rules, or if I take the MCIA rules, or the DIAC rules in Delhi, and I can choose any of these, there's a provision for consolidation, there's a provision for joinder, which means I have consented to consolidation, I have consented to joinder. And in those circumstances, yes, multi-party disputes may well be joined together, but there is consent by accepting a set of rules, but not in an ad hoc situation. And that's really where 73 then becomes tricky, because it leads to greater uncertainty. And 76, and the reason why I say it becomes a bigger problem, is that when it talks about the mother agreement and subsequent agreement, it has a fundamental bearing on interpretation of contracts and the point of time you decipher intention. Let me just read out 76 more and then highlight the two problems. Paragraph 76, Cloro reads as follows. The court will have to examine such pleas with greater caution and by definite reference to the language of the contract and intention of the parties. In the case of composite transactions and multiple agreements, it may again be possible to invoke such principles and accepting the pleas of non-signatory parties for reference to arbitration. Sorry, from the second sentence it should have been in red. Where the agreements are consequential and in the nature of a follow-up to the principle of other agreement, the latter containing the arbitration agreement and such agreements being so intrinsically intermingled or interdependent that it would be their composite performance which shall discharge the parties of their respective mutual obligations and performance. This would be a sufficient indicator of intent of the parties to refer signatories as well as non-signatory parties to arbitration. The principle of composite performance would have to be gathered from conjoint reading of the principle and supplementary agreements on the one hand and the explicit intention of the parties and attendant circumstances on the other. Both paragraphs 73 and 76 are inconsistent with two fundamental concepts. 73 permits a non-signatory to be roped into an arbitration agreement merely on the basis that there is direct commonality of subject matter and the agreement between the parties constitutes a composite transaction that is insufficient to justify consent. 76 is inconsistent with the basic principle that intention of the parties to an agreement must be determined not only from the text of the agreement, but also from the date of its execution. If on the date of its execution there was no, then it would not be envisaged that an arbitration clause in a mother agreement would bind a subsequent agreement unless so expressly provided. That's when your doctrines of incorporation, etc., will come in. Because if I have signed an agreement on the 1st of January 2023, and it's a long-drawn contract, and I sign another agreement on the 1st of January 2024, and that either has a separate dispute resolution clause or has nothing. From a contractual interpretation perspective, how can you say that your mother agreement, which is 1st of January 2023, envisaged that subsequent disputes in a subsequent agreement would be covered by that agreement? That could never have been the intention of the parties unless it was expressly provided for. Saying all future contracts or all disputes arising out of future contracts will also be a part, but it's a separate contract. And it happens. There have been many cases like this. And Cloro was a case like this because in Cloro, the finding is subsequent agreements Disputes under subsequent agreements can come back to the mother agreement. And those, if your lordship recollects, in Chloro had their own arbitration process. How could that be the basis to decipher intent? Because when the mother
It should
agreement
be
is
the, we get that point, Mr. Divan, that point is well taken. You don't need to labor on
Very
that. All those passages in Chloro and subsequent, the point is well taken.
I'm
You
sorry.
have understood your point. Now, move further.
I will.
Tell us, which is the method, what is the method? What is the process by which
Yes.
we would arrive at the actual consent
certainly
that you are
go through that.
propagating?
very
I
good.
Go to your
para
para
28,
31,
28,
31,
31.
28 and 31.
Very good. So I will skip.
Let's go to,
I'll skip a couple of paragraphs. So it's 21.
We see
now come to 28 is where you quote
28,
red
then you
fern.
start actually.
So 21, 23, 25 words, in my respectful submission, point to
Same thing.
the same kind of problem.
Same thing. Same thing.
Just one greater concern which arises from the ONG. Just have a look at para 25 of my submission, where your lordship
That these paragraphs allow non-signatory to be bound without consent would make them inconsistent with the fundamental facet of arbitration, can only be resorted to with the consent of the party.
And it's that little part that I wanted to refer to from ONGC, which is problematic in my respectful submission rules, is that paragraph 30 of ONGC, where it is said, it noted that written intention to arbitrate between parties can extend to bind non-signatories with the aim to target the credit-worthy member of the group of companies.
This is what red fern says, which you have quoted yourself.
I have.
Then exactly, we have referred to red fern, we have quoted red fern there.
That's why I'm not from saying, I'm not from.
See, where you have referred to red fern
I
yourself.
certainly have.
Red fern expressly refers to what is the purpose of the doctrine.
That's right. Now, paragraph 27, your lordship is absolutely right. I have referred to Redfern and how Redfern reads down down.
That's right.
And what Redfern effectively was at paragraph 27. I mean, what I've said at paragraph 27 says this. Read Dow as being a group of companies doctrine. Read Dow in what it really should be.
Dow for us is not the statute. Correct?
Not just a statute, but
In other words, go by section 7.
In fact,
what the law is.
And in fact, at page 11, para 27, 2.54.
I've highlighted that.
According to the Dow chemical case, may perhaps be best characterized as authority that conduct can be an expression of consent, and that among all the factual elements, the existence of a group of companies will be relevant.
I'm so deeply obliged. I'm so deeply obliged. That's what I highlighted to your lordship's time consideration. Now, your lordships has all of these judgments. Your lordships has Redfern, which I have quoted notes and extensor. But am I asking your lordships to just simply subscribe to what is set out in Redfern? And my respectful submission was this, because there is a little balancing that's required. And that balancing is what I have set out at paragraph 28. And there, Manoj, I will
Now go to para 31. That's where your 2 points which you are making. How to really then infer what kind of conduct and what kind of consent or implied term.
One is that, and then towards the conclusion, I give you a lot of stuff. Can I read out 20? Because there's something critical there. Because there's a little balancing that's required. It is respectfully submitted that the evaluation that is to be conducted.
There is a para 20.
This is the evaluation to be conducted. The presumption must be balanced. These are the presumptions which have been drawn by Redfern, with the equally compelling fact that the party who has negotiated a contract have deliberately chosen not to be bound by the arbitration agreement by having the contract executed through a subsidiary or a sister concern. The action of stepping away and limiting liability may well form the basis to demonstrate an intent not to be bound by the arbitration agreement, which at the point of execution of the contract has been accepted by the party. And that's my point. When your lordships has doctrines such as...
But therefore, are you saying that basically no party which is not a signatory to a contract can be bound by the arbitration?
No, there may be circumstances where you may have accepted...
Obviously.
Where you may have written, but today, if there is no such, don't just look at your lordships to balance the evidence. If there is no evidence, supposing I have negotiated the contract, but finally signed by my BVI subsidiary. The counterparty has been perfectly happy executing the contract with the BVI subsidiary. I have, using my group structure, shielded myself. Am I not entitled to do so? As long as the counter... Why should that I'm the sugar exporter. Of course, it was happening. But it's a high-sea trade happening with my BVL subsidiary. It happens all the time in India.
So precisely, Mr. Diwan, a party or a group company can arrange their affairs in a manner that I consent to move away from this particular part. This is what you are trying to say.
That's correct.
So we are talking about determining the consent. Here we can easily see there was to move away.
Yes.
So that is what we have to sort of focus on in a situation.
That's right.
When affairs are arranged in that way.
I'm so deeply obliged. What is it by reading all of these decisions? I can tell your lordship with some amount, with some experience that I have in this, that these decisions are being read to say it's a composite transaction, you're performing the contract, that's only a subsidiary, you're roped in. That's the concern. And nobody is looking into the fact that, yes, of course, I may have negotiated, but I stepped back and you perfectly well agreed to allow me to step back and step out of it.
Para 34.
Yes, let me straight away look something. So now the test.
34, 35, and 36.
Yeah,
you have laid down
the
the
test you're looking for,
Yes.
what you're suggesting.
That's
is
it.
that-
So look, the test that I am suggesting will derives itself from various one looks from a US decision which is set out in the consent to arbitration, which effectively says there must be a clear and unmistakable intent to arbitrate. And also this must be from a dispute resolution perspective, from the doctrine of separability perspective. And what is also set out by Dalla in the concurring opinion of Lord Collins at paragraph 122, where right at the end of paragraph 30, what your lordship should see the last 4 lines, it would have to be a conscious, deliberate act by the government. That anything less deliberate act of the government make it less relevant. This was the government of Pakistan, and the letter would not be relevant.
Para 31, there's two tests.
That's right. I set out in the additional skeletal submission, the paragraph
Just take
7.
one there.
I'll come to that. The conduct of the non-signatory party demonstrates to be bound by the arbitration as a separate document, as a separate contract. Think my disputes you will be arbitrated. And the incorporation of an implied term in a contract where a non-signatory is implied to be a party to an arbitration agreement. These are the two bases which, if clarity is brought out here, will make it significantly easier. And these are exceptional circumstances. If there is something which meets the NABA power penta test, and you can get me in. But if you can't, then you can't. So these, and
Now see para 34, 35, 36
Yes.
is important actually.
that's it. So how I have now distilled section of the Arbitration Act is as follows. I'll just read out the first part of section 7, which says arbitration agreement. In this part, arbitration agreement is an agreement by the parties to submit to arbitration all certain disputes which have arisen or between them in respect of a defined. Now, I divide that part of section 7 into 2 parts. There are 2 parts of section 7 of the Act. I'm reading paragraph 15. The first of which is the agreement by the parties to submit to arbitration certain disputes. So that's the first part. The second part of section 7 relates to the manner by which such disputes will arise under a defined legal relationship. Now, in these proceedings, binding a non-signatory to an arbitration agreement ought to be considered the first part of section 7, which is whether there is an agreement by the parties to submit to arbitration. It is only on the conclusion of such inquiry that the basis and substance of the dispute which may have to be arbitrated are required.
So,
So that's how I break section 7. And what I also must further submit is that it is, paragraph 35, is that the definition of party ought not hinder your motives. Because a party, I will say, should be the real party. Because 2(1)(h) says unless the context requires otherwise. So your lordship is not bound by just the definition as it stands. And therefore, the paragraph 36, I say, if in a particular case it has to be asserted that the real party to the arbitration agreement is a non-signatory, then the definition of 2(1)(h) ought not come in the way of restricting the arbitration only to the signatory.
Now just let's see your conclusion, Mr. Diwan.
Yes, just the little point of claiming through and can you?
Through and under which, okay, Mr.
That's right. I'm not going to repeat anything there. But please remember just one thing. When the Section 8 and Section 45 come into operation, I have filed a suit in India. Very clear. It can only be related to an Indian suit or any other Indian proceeding. A non-signatory comes claiming through and under. Say, why have you filed it against me? I am claiming through and under against this as a defendant. Send me to arbitration because there's an arbitration agreement with somebody who's a signatory. Certainly the signatory comes no difficulty. It's a direct 845F. Claiming through and under is actually a defendant's doctrine. It's meant for a non-signatory to come in and accept that obligation to arbitrate. Because the other person who has filed a suit says, yes, I may have a contract with person X. Maybe you're the assignee, maybe you're not the assignee. I don't know. Maybe you're the parent company. I can't go against it. I file a suit. Parent company comes and says, no, I'm claiming through and under my subsidiary. I am the real party. Send me to arbitration because your contract has. So it's a defendant's doctrine. And what I'm only saying is this. That defendant's doctrine under 8 and 45 cannot be used to just bring a non-signatory group of companies, which is where there's been a conflation in my respectful submission.
All right, let's go now to the conclusion.
No, I'll certainly now come to the conclusion. And the point we make is this. It is respectfully submitted that this honorable court to set aside parts of the decision in favor and subsequent judgments that allow arbitral tribunals to commence arbitration only on the basis of the GOC doctrine. The GOC doctrine cannot, without more, extend an arbitration agreement to a non-signatory. The determination of the real party to an arbitration agreement must be reflected on the execution of the arbitration agreement. This approach would balance the public policy between certainty of contracts as well as resolution of disputes and would not be antithetical to the development of arbitral jurisprudence. That is because there are other recognized doctrines on the basis of which multi-party disputes can be resolved under the broad umbrella of a single determination. These include concepts such as recognition of a single arbitration to the doctrine of incorporation by reference, or in the case of institutional rules, providing for consolidation of disputes. As Maharashtra notes, joinder and consolidation of disputes is an issue distinct from the issue of extension of an arbitration clause to a non-signatory, and therefore the policy considerations for the two should not be conflicted. And that is unfortunately what has happened with Chloro and the judgments which have gone down. But I want to answer one question which my Lord Justice Roy had raised, not today but a couple of days ago. From a construction contract perspective, employer, contractor, subcontractor. Mr. Kambata had made certain submissions, which I adopt. But under the FIDIC rules of contract, which again internationally for contract becomes very, very relevant. And I've quoted this. Article 4.3 says that the subcontractor has no privity with the employer. Now, if your lordship's lords under Indian law says, sorry, in such a situation, because of composite transaction, because at the end of the day, you subcontractor are only performing for a contractor who's performing for an employer, I can rope you in. Then it's going to be against the FIDIC rules for construction of contracts. So the construction industry, in my respectful submission, gets into a bit of a dizzy. Well, let's take international trade. The way companies are set up for international trade and commerce, again, provides group structures. And therefore, I would be very hesitant in accepting, as the other side says, Chloro in its entirety. And the judge.
Right. Thank you, Mr. Diwan. I think thank you very much, Mr. Diwan.
But I'm so deeply obliged. Well, all my references, I'll just take one. I'm not going to make a take a my first skeletons and my additional skeletons, and these will make a reference to everything that is relevant.
Thank you, Mr. Diwan.
Because I'm so deep.
Anybody else?
I had just 5 minutes.
I appear for,
Yes.
But go ahead, file detail.
Where were you all through?
I was here for respondents number 1 and 2.
How will you be able to argue? You don't have any idea of what has happened before you
have no idea.
Matter.
No, I've been watching the proceedings.
We wouldn't have missed you.
You are watching on the virtual mode or physical mode?
But physically and as well as virtually, whenever I could not be here. I knew lot.
What is the point you want to make here? What is covered so far?
But I had just made 3 charts if lots of permit me.
Charts, all right. Give us the charts.
But I just wanted to, my lord, just put some.
Chetan,
But I just wanted to, my lord, just place before lordship, just the elephant on the table, and this, my lord, unfortunately, I don't have solutions, but I was raised certain important issues, my lord, the lordship to consider. But one is, my lord, which fell from my lord Justice Narasimha on the very first date of the hearing, and which my lord the Chief Justice, my lord, picked up on the issue of my lord, parole evidence. That, my lord, common law jurisdiction, my lord, we go by, there is an aversion to parole evidence, and we go by what is the written document. And therefore, my lord, we come to section 7 of the law. Now, my lord, the difficulty comes, my lord, when we come to, my lord, 8, 11, and 9. Because the difficulty will be, my lord, that when there is certainty in section 7, that we know those A, B, C, D, E, and they are all written. It may not be a written signed document, but there are exchange of between parties, written evidence. One of the section 9 judge, section 8 judge, and section 11 judge has clear, my lord, evidence before it, primary evidence before it. Now, my lord, what happens, my lord, when you don't have that and you have to go beyond the world? Well, that is why the difficulty will happen, Malad, if this group of companies doctrine traverses beyond Malad, section 7. Malad, for example, in our case, my lord, it took 3 years and we suffered an interim order. So much so, my lord, there was a restraint on alienating assets.
So what would you like to, how do you formulate your submissions?
Yes, my lord. My first
points so that you can just take them down.
Yes, my lord. My first proposition, my lord, with lordship will see from the chart which I've given, the first chart. My lord, what the group of companies doctrine does is it conflates, my lord, two contrary concepts. If lordship sees the chart, my lord, I have given at the first paragraph, my lord, is called the which requires presence of wrongdoing, and the second column is absence of wrongdoing. Now, my lord, Professor Gary Bond calls the first one non-consensual, meaning, my lord, that there is no requirement.
How did you formulate it?
May I formulate that?
First proposition you were saying.
My first proposition is the group of companies doctrine conflates contradictory propositions of law and hence is unworkable.
Which are those contradictory propositions?
Please, my lord. My lord, if lordship has my first chart, the concept of alter ego.
The concept, we are taking it down now. The concept of.
Well, I can submit for me. I can give submissions later. The concept of alter ego, sham,
the concept of alter ego.
Concept of alter ego, my lord, is based on wrongdoing. And there has to be egregious fraud or some kind of sham, evasion, some kind of wrongdoing has to be there, my lord. And here, my lord, the intent is not so much as whether you're intending to be bound by the arbitration agreement.
All right. So
one is alter ego.
Alter ego.
Second,
sham, evasion of statute, facade. And my lord, I've given the judgments where my lords have in several cases explained this, including, my lord, the recent case in Balwant case. Lordships have, my lord, dealt with this issue, and lordships have that it is not just having a tight control company or closely held companies. There has to be some element of fraud. There has to be some intent to avoid obligation or to defeat a statute or avoid evade payment of tax.
All right.
And what Professor Gary Bond says that this is non-consensual, meaning that even if you did not intend to be bound by an arbitration agreement, if your intent was to avoid and evade, then you're still bound. And he, of course, applies the group of companies doctrine and says that in such circumstances also a non-signatory entity is bound by the arbitration process.
All right. There's the first proposition.
Yes. Well, in contrast, my lord, lordship sees the other, my lord, commonality of subject matter, existence of group of companies, composite nature of contract, performance of contract, single economic reality. But these, what lordships have over time, my lord, etched out as attributes of group of companies doctrine, my lord, are all not based on wrongdoing. It's simple that, for example, my lord, in MTNL, lordship said if there's a tight economic structure, even if there is no wrongdoing, even if there's no evasion, even if the intention is not to avoid a group of companies, and you're bound. Now, my lord, the difficulty is, as I was saying, my lord, is section.
So what you're really saying is that the whole concept is intended to reach out cases of fraud, positive wrongdoing.
I'm obliged.
And,
I'm obliged.
These aspects which have been highlighted in chloro, they really are not based on wrongdoing at all. You may have a composite contract, you may have performance by one
Absolutely.
of the obligations of another without any.
I'm obliged, my lord. I'm obliged. And if 7 is absent, my lord, if the 7 test is absent, you cannot bring in such.
We got that, yes.
That's all. Well, the second, my lord, related to this, my lord, and my lord, this is the issue. My lord, of course, my lord, I'm trying to pitch it at a level, my lord, I don't know whether Lordship will accept this. But what I'm submitting is that even with regards to, and my lord, this is where Lordship will have to reconcile, because I've given the contradictory judgments of all the high courts, my lord. Even when it comes to egregious fraud or alter ego piercing, my lord, Honorable High Court of Delhi and Honorable High Court of Bombay and Honorable High Court of Madras have taken contradictory views. Coordinate judges have taken contradictory views, and I've given the, my lord, the table in the third table. I will not read it, my lord. But that an arbitral tribunal, being a creature of a contract or with a specific remit, will not have the plenary powers of the court. Well, these judgments are post-competence, post my lord's chloro control. The learned judges are aware of all this. Yet they hold, my lord, that a court, an arbitral tribunal being of limited jurisdiction, cannot pierce the corporate veil, and that can only be done by a court of plenary jurisdiction. My lord, just to name a few judgments, my lord, in the Delhi High Court, my lord, I've given in the third chart, Sudhir Gopi versus IGNOU. My lord, Justice Bakru's judgment is there. And my lord, Bombay High Court Justice Gupta's judgment of NOD Bearings Private Limited, I've given as serial number 3, my lord, of the third part, my lord. I've just extracted these judgments. I didn't want to waste Lordship's time by going through my submissions, but I've extracted those parts where these the discussion is there, and the High Court says that it cannot go, the tribunal cannot pierce the veil. So my lords will have to reconcile this, and my lord, of course, Lordships will hold one way or the other, that whether this group, I mean, I've given also, my lord, the other judgments which I've held, they can do it. So my lords will have to, my lord, reconcile this issue. And my lord, the last thing I would submit, my lord, and this I was submitting on Vidya Dolia, and I'm done, my lord. In Vidya Dolia, my lord, Lordships have, my lord, made the it's not an exhaustive list, but Lordships have given certain exceptions to arbitration. Now, my lord, 2 exceptions, if I may, my lord, place for Lordship's consideration. My lord, one is when there's an adjudication at rem, or it has an effect at rem. And the other is when there is a statutory machinery provided for the adjudication. And Lordships have, in both these circumstances, it is out. The arbitral tribunal cannot enter into this domain. And my lord, I have given in that second chart, my lord,
First instance, in the case of in rem would be a probate.
I'm obliged.
And the second would be surface, where there's a example.
Deeply obliged. Or in my case, my lord, I would submit if Lordship considers the Companies Act. Because my lord, in the Companies Act, and I've given the sections in the second chart, all the provisions are there for inquiry and investigation into the character of the company.
Right.
Now, would Lordships, my lord, permit a tribunal, which is a creature of 2 parties agreeing to an arbitrator who may not be a trained lawyer? There is no, my lord, obligation. As Lordships said the other day, it could be a technician, it could be an engineer, an architect. Would Lordships say that the power which is vested in a tribunal by the statute of determining who is the controlling authority, or would that, my lord, be given to an arbitral tribunal? Ultimately, my lord, certainty, my lord, which is the issue. My lord, I'm obliged. I'm so sorry, my lord, I interrupted.
Thank you.
Right away.
That is thank you, Mr. Ghosh.
Can I have just
Yes.
a few minutes? I'm for respondent number 1 and 2.
But 1 second, where is George Poten gone?
Yeah, I know.
There you are.
Yes, yes.
Are you wondering where you suddenly disappeared? You disappeared behind the scene, George.
My lords, I appear for India in IA number 69863 of 2023.
You appear for the National Coordination Committee
of UNCITRAL. Having heard the arguments at length, now my lords have the benefit of hearing both sides, the views of both sides on the issue of group of company doctrine and arbitration and the various views across the globe. My lords, at the outset, I would just like to mention that UNCITRAL does not per se have a group of company doctrine, but looks at non-signatories to arbitration, corporate structuring. This is what UNCITRAL has looked at. The mandate of UNCITRAL, that is the United Nations Commission on International Trade Law, encompasses promoting ways and means of ensuring uniform interpretation and application of international conventions and uniform laws in the field of international trade law, collecting and disseminating information on national legislation and modern legal developments, including law in the field of international trade.
You have a note? Give us a note.
I'll give a note after this, my lord. I'm just skipping most of it, was already covered. I'll prepare a note with comparative.
So what is tell us, just formulate what your point is, George.
My lords, I'll just draw a comparison between the Indian Arbitration Act and the UNCITRAL model law, the 2006 amendments to the UNCITRAL model law, the reason for the amendments, and I'll also touch upon the New York Convention because the model law complements the New York Convention. And last point would be on arbitration without privity. In this regard, it's pertinent to note that the Arbitration Act of India is based on the model law, and there is reference to that in the preamble and in the statement of objects and reasons of the state. So the legislative intent is clear that the Indian model law.
So where does UNCITRAL stand? UNCITRAL stand on the group of companies doctrine.
My lords, the UNCITRAL has brought about the 2006 amendments to accommodate non-signatories to the arbitration. This I'll just.
Where do we get? Standing on the wrong side.
Sorry?
Standing on the wrong side.
Well, I mean, it's non-signatory is not a group of companies doctrine. That's why I said it's. I mean, neither here nor there. But I'll just put it across what exactly it's.
I don't know how many countries have accepted the 2006 amendment.
Yes, I'm coming to that. Like.
Mr. George, why don't you give us a note on this? Because
I'll give a note on this. I'll just quickly go through the.
Because that will be better. We'll be able to then see how it has evolved.
Yes.
Perhaps you have prepared a note which also takes into account other this thing, but so you can just consolidate and sort of reduce the note and then give it to us.
Yeah, a lot of it was a repetition of what.
That is what we're trying to avoid that. So in your note, just delete the part which have been covered by the others.
Yes.
And
right
focus
now,
on UNCITRAL.
And right now, just sort of formulate your points and
yes.
You can give us a note. So just in 2 or 3 points that you want to make, you can tell us, take it down.
Yes.
So is there any suggestion that you have or any idea that you would want us to know? Just you can tell us that.
Yes. It's page, if your lordships could have volume 1 of my compendium, page 33.
Just formulate it, Joe.
Yeah, I'll just read this out. It states the reasons why the amendment was made. Article 7 was amended in 2006 in order to respond to concerns voiced by an increasing number of scholars, practitioners, and judges who are of the view that formal requirements set out in the original version of Article 7 should be amended to better conform to international contract practices. It was pointed out by practitioners that in a number of situations, the drafting of written documents was impossible or impractical. In such cases where the intention of the parties to arbitrate was not in question, the validity of the arbitration agreement ought to be recognized.
George, you put all this in the note.
Yes.
Make it a short 3 or 4 page note and give it to us.
Yes.
We'll have a background of why the 2006 Act model law, why the model law was amended in 2006.
Yes.
How many countries have accepted the broadening of the definition
Yes.
In the arbitration agreement?
And yes.
You can give it to it. Let's call upon the other side so that you can.
If you can just touch upon 2 points and just on the arbitration without privity, because I mean, Dala and those chemicals have been dealt at length, so I'll not touch upon that once again. But on Article 7, my lords, if I could just quickly have it's.
Now we are in.
the article
George, give us a note. Just give us a note.
Sure.
Very, very, very brief. I am for respondent number 1 and 2 in 5101.
Ms. Arora, you're on the right side, right? George was on the wrong side. I hope you're on the right side.
I am on the right side.
Right side in the sense that you are supporting the group of
I am
companies.
completely supporting the arguments that have been advanced by the learned Solicitor General and Dr. Singhvi. And I support the principle of group of companies to be read in. I only have a very, very brief, let me just make
Tell
the
us your
points
point.
very clear. My lords, first of all, I have heard whatever I have staged now. All these matters, Mr. Devan has appeared for respondent 9 in 501.1. I believe Mr. Darais Kambata has appeared for respondent number 8 and Mr. Ghosh for the petitioner. Now, what's significant in this matter is that this matter does not arise out of section 11, it arises out of section 9. And section 9 is very distinct and different from section 8 and section 11 because section 9, while the court may have applied the principle of group of companies to pass an order restraining the parties because of the very nature of the contract, but section 9 principles are entirely different from that of 8 and 11. My lords, by various orders, it has now been held that third parties can be joined in the matters of grant of interim relief, protection and preservation, before, during the arbitration, and also after the award, till such time as it is executed. So therefore, the arguments that have been advanced, and I believe it was suggested by my learned friend that the issues are different and should be detailed, I only want to put this on record, lest the final order deal with setting aside the interim protection granted by the High Court. My lords, I have placed the judgments under section 9.
So, which is your matter? This has to be
My
dealt.
lords, this is McLeod Russell versus KKR India, where everyone seems to have expressed an argument on 8 and 11. My lords, it is
501.
it's 501.1. It's 8607 of 2022.
The most we hear, we will take it that arguments were addressed on the general.
That's right.
We're not going to-
I am grateful. My lords, I needed that clarity.
Before the regular.
We are not going.
I needed that clarity to be in because I didn't want to be faced with an order suddenly setting aside an interim protection.
We're not
Now, my
deciding
lords-
individual cases.
Yes.
Mr. Arora,
Now, my
he
lord,
made that point.
come
Mr.
to-
Kambata, in fact, clarified that we were only arguing on law. And
Very well.
all of us have been only arguing on law. None of us have really gone, I mean, your lordships haven't even touched the facts in McLeod.
Now, my lords, coming down to very, very briefly, and I will just take about 5-7 minutes of my lord's time and no more, because most of the judgments have been read, and I'm not going to read it except to the extent it may be absolutely necessary. My lords, the entire principle of group of companies is based on an aspect of, as my learned friend argued, is protection holding companies, subsidiaries, etc., which may be within the group. It is well recognized in the matter of corporate structuring that very often there are companies which have no or little assets, and a holding company may be the one which will hold all the assets, and they may be only leased to the subsidiaries, or it may be vice versa, and that is to ring fence and protect yourself from the arm of the law in the event either the subsidiary or one of those group companies gets exposed to liabilities. That is a principle my lords will find in respect of structuring of the holding companies or the group companies very well settled, because the idea is a protection.
Argument has been that, look, short of a case of egregious fraud,
Yes.
these are structural arrangements which the law does recognize.
I have no issue with that. They may be done for the purpose of taxation, they may be done for whatever reasons, ring fencing, protection. I'm not on that aspect at all. but I only want to restate the principle when I show the judgments, whether it comes from Chlorocontrol, Chevron, MTNL, and the last one in ONGC, that the court reaches out on what was your intent, was what, as it was argued just a few minutes earlier, was it your intent that I'm not going to allow an exposure of my assets into this contract, or did you conduct yourself in a manner which was representative to the other party entering into the agreement that yes, companies within the group will stand for the liabilities, obligations under the contract. That will be the test. And in that context, if we start from Chlorocontrol itself, if my lords, may I not take you to the judgments? If my lords have the written submissions filed by my colleague, I just want to show those few words. By Apur Shukla.
Yes.
501.1. And therefore, if I have that context clear, each one of these judgments only signifies that what will be that nature of conduct, intent, reflected from the facts which will bring the group companies into the purview. Fellows, we say a lot about non-signatories to be taken out. The principle is that each one of the judgments says non-signatory group companies. So the question of signatory does not arise, because if they were signatories, they were automatically bound by the contract and the arbitration provision. Because they are non-signatory group companies, therefore the various principles have been set out in each one of the judgments. Just few minutes and I will satisfy that. My lords have my submissions. Would
Yes.
my lords turn to page 17? First of all, Chlorocontrol. I'm only going to read few lines and few words and phrases in them, because my lords have already read these judgments extensio. I'm not going to take again that. My lords have page 17.
Yes.
This is a part of paragraph 72 at the bottom of the page. This evolves a principle that a non-signatory party, now my lords may mark the word, first of all, we are understanding that the party is a non-signatory, could be subjected to arbitration provided these transactions were with group of companies, and then my lords, the principle is set out in Chlorocontrol with great detail. Please remember the principles on the holding, subsidiaries, assets to be there or not available. Clear intention of the parties to bind the both. So therefore, first thing that the court will look at, was there an intention? What are the factual backgrounds to establish that intention? Both the signatory as well as non-signatory. In other words, intention of the parties is of significant feature. So the principle that the court said was intention. Now, my lords, please, page 18, 3 words in 103.1. The court sets out these principles. So these principles have actually been laid down. The first theory is that of implied consent. So the court will look into the facts to see whether there was an implied consent. Did you participate in the negotiations? Did you make representations at that time that yes, this will be done through our subsidiary? Are there back-to-back contracts where you took a subcontractor to execute your contract, but he's not a party to the main agreement, etc.? So, my lords, we have to look at each one of them. Next, third-party beneficiaries. Simple classic example in 501.1. A loan of 100 crore each is advanced to two companies which have no assets. That loan, they are only the companies which take the money and pass it to the other group companies. So those two companies take 100 crore each from respondent number 1 and 2, pass it on to their other two companies. Now, there are orders which have been there, representations made. Those companies will not pledge their shares. Those companies will not alter their status as being into public listed company. They shall maintain their EBITDA, etc., etc., etc. Who has made the representation? the parties that hold 49% odd shares in those companies. Well, this is a conduct, this is a beneficiary, this is an implied consent, guarantors. Assignment and other transfer mechanisms of contractual rights. So this is the principle that Chlorocontrol said, we will look at these factors to see whether these non-signatory third parties are assenting to will be parties to the arbitration. Now, my lords, very quickly to Charan, if my lords may come to page 19. Would my lords just come to the highlighted portion? In holding, my lords have that, in holding a non-signatory bound by an arbitration, the court approaches the matter
These are extracts from.
My lords, yes, these are paragraphs. What I am only trying to establish before the court is that each one of these judgments set out a principle or a circumstance where it believes that in these particular fact and circumstance, a non-signatory group company would be amenable to be joined as a party to the arbitration, whether it was Charan or for that matter MTNL and subsequently ONGC. And in each one, my lord, different principle or a test which is laid down. Like, may I just quickly.
It's there. We don't need it. We have looked at these judgments.
Yes.
And we'll also note here that this particular matter 9, in any case, section 9, no question of detagging because they're not going to decide it on
That's
this
right.
at all.
But in fact, that submission was made and
Yes, that's right.
none of us have touched the facts because in fact, we've been very correct.
Yes, yes.
We have your written.
Other submissions are there.
So, my lords, that is my principle in terms of understanding the principle of a
Right.
holding subsidiary,
Right.
management of ring fencing, protection. Then what
Right.
are those aspects that the court will look into? My lords will find it here. The only judgment that hasn't been set out here is that of ONGC. Yes, yes. And my lords, in ONGC, I would request my lords to look at paragraphs number, just give me a moment, my lords, page 283. Because principles in all these have been set up. ONGC.
Tell us.
Yes.
Para?
My lords, paragraph 37 onwards until 41.
Okay.
Para 36.
And those same principles have been then culled out as to where you would then have a non-signatory third party joining in an arbitration. So, my lords, to say that section 7 requires it in writing, etc., the principle is entirely different. In what circumstances would you have the non-signatory party?
Thank you so much.
Now, and my lords, the only other thing is that this particular reference will not apply in case of section 9 because I'm
That
not.
you have already
That you have said.
Not
Please
under
clarify.
that principle, it's entirely different from 7, 8 and 11.
Yes. Thank you.
Great.
Ms. Dr. Singhvi, how long would you take?
It's your lordship has a special bench at 2:55. I have to finish before that. I'll finish. The lordship has a, not that whether this work will expand to fill the time available to do it. I actually have more time. I need more time, but I'll finish before your lordship's bench.
Lunch. Just broadly, what is
Yeah.
your submission going to be, Dr. Sri?
It'll be faster if your courtmaster can put three notes, three things. One is my note, which I gave you lot in the opening, or should we call it note one. One is a rejoinder note I have given now, which is a pointed one. Argument this, answer this.
Right.
Argument one. And third is CL1. There is case law one. There are also case law 2 and 3, but these three will cover 95% of my note. So my argument is simple that your lordships has to really ask two or three basic questions. I'll take only a minute, your lordship is rising. One, well, as I say, the life of law is not logic but experience. So, well, if your lordship were to go strictly by logic, your lordship cannot have anybody not signing going to arbitration. That's the correct way to look at it. Now, obviously, that's not what the lordship is going to do with justice. Where is the intent? Second error, only wrongdoing will display my intent. My learned friend says, where is wrongdoing positive or negative, you will send me to arbitration. Can't you have an intent to go with your sister concerns, group companies to arbitration without wrongdoing? Third, well, if the shield is made to, as they use the word ring fence, then well, if your lordship applies any of those 10 tests and finds A, that there is fragmentation, your lordship finds that the entire intent to settle the dispute or arbitration is frustrated by two companies being out because it is ring fence. So your lordship's doctrine is a superimposed doctrine which goes, of course, to the true intent, but along with intent sees all the other intent tests I've already given. That's going to be our broad.
Yeah.
I'll proceed quickly. I'll proceed quickly to give a few minutes to
Yes.
Advani and
Yes.
One part of Ms. Arora's statement, because she's here for the first time, one aspect I need to respond to, I need about a minute, not more.
now, so therefore, Lordship will have these three things open: my original note, my rejoinder note, and my CL1, which is case law 1.
1 minute up. So. Is also rejoined.
Which was circulated earlier today. And one list of authority volume 1.
List of authority volume 1 I got. Yes, we joined the submissions also.
Written submission is second last.
We joined the submissions. Volume 1, right? Yes.
Each of my lords has got that.
Yes.
Yes. Now let's. I've got about half an hour, so I'll be very pointed. So they have about 10-15 minutes left between them and us. Please see the larger issue for a minute, and then I'll read only some part of these two notes.
The rejoinder one?
Otherwise-
Which one you want us to take first?
No, Lordship may have all three open. I'm not going to follow this sequence because I'll just go between rejoinder note, my first note, and CL1.
Yes.
These three things are 95-98% of my solutions. I'll take a different sequence to make it shorter. Right, Willis? Now, my opening point is, Willis, that Willis, if your lordships were to go by this, what I call the absolutist theory of signatory or Willis party in that sense, then your lordship must throw out completely the doctrine. If not, then the best your lordships can and perhaps should do is to consider where the existing law needs trimming or safeguarding. That's point number 2. Trimming is a more appropriate word. Why, Willis, I say trimming? Because according to me, my lords has already fleshed out 10, 12, 15 legal principles, which ring fence that doctrine already from abuse. Now, certainly to the extent my learned friends on the opposite side tell your lordships that this doctrine ring-fenced by these 15 principles needs further tweaking in this particular sentence, I am with them. I have no problem. But the problem with this case is they have not told your lordships that. They are suggesting again and again, by creating an apprehension without telling your lordships which of those safeguards needs tweaking, so as to actually reduce the doctrine to vanishing point. So, without telling your lordships, because they know they can't say that, they can't tell your lordships normally, please throw out the group companies doctrine. Actually, that is a logical thing to say on their side. Realizing that that may either be unpalatable or discretion is the better part of valor, they say, no, keep the doctrine, but put so many unknown conditions which reduces to vanishing point, which another way of saying throw it out. One of those points is, must be positive or negative wrongdoing only. Only an example, I'll be reading in a minute. Take, for example, the repercussions of that point. That means that absent even piercing the veil is not merely based on wrongdoing. It's a misrepresentation to your lordships to suggest that piercing the veil is based solely on wrongdoing. My lord pierces the veil in a wider set of contexts. But Wallace, that would mean that your lordship will either equate the group doctrine only with piercing the veil. It's not the way it is put by the other side. It amounts to that. So, Wallace, please ask them which particular safeguard, and the lordship is to be reminded of those 15 safeguards. Please ask them which of these safeguards is not enough, in what manner. That's a constructive exercise. I would join them in that. But Wallace, absent that, please don't let it be reduced to vanishing point by a circumvention or a camouflage. That the doctrine is okay, but in some unstated manner, don't apply it to a non-signatory or to a non-party, which means there is no doctrine at all. Now, with that backdrop, please turn to Wallace 3 portions in a different sequence. First, turn to my rejoinder note, the last page. I'm following a little different sequence, Wallace, it will be quicker. But remember these 3 points, Wallace, which I have said in the opening. With that backdrop, kindly turn to the last page of my rejoinder submission.
Para?
The very last page, it's a kind of an appendix. It's not a
Oh.
para. Does it have the title, Wallace, Test for Recognition?
Yeah.
Now, Wallace, what I've done here is I've done the reverse, and I think you'll actually find it useful. I have, Wallace, put the test or the concept and then the case law under it. It's already there, but I've done the reverse. Now, Wallace, just give me a few minutes. I'll not read a single case on this page. One test is intention of parties, commonality of interest necessary to bind non-signatories. First of all, Wallace, as my learned friend Miss Arora also said, I said in the opening, this non-signatory is, Wallace, a complete red herring phrase. This phrase non-signatory actually has no place in this jurisprudence. I'll tell you why. Because if you're a signatory, the doctrine doesn't arise. It doesn't arise. Then you must have an all or nothing. The moment you are not a signatory, the doctrine doesn't arise. Full stop. Your lordship must throw out whatever your lordship wants to throw out. So the whole doctrine is, yes, a non-signatory can be there. To what extent?
Express party, implied party.
Implied party. Now, so non-signatory, of course, we are using in the jurisprudence, so it's okay. It can go along, but that's the concept. Now come to this. Intention of parties, commonality of interest necessary to bind non-signatories. Now, let's just see. These are chapter and verse specific paras where my lords has in 3 judges, 5 judges, or 2 judges laid it down. I'm saving time to specific paras pinpointed. And I'm grateful to my learned friend, Mr. Himanshu Mehta, for having done that exercise under my supervision, but it's useful to have it called out. And I've got CL1, which is your lordship's volume 1, otherwise sometimes CL2. Now, so many times your lordship has done it, the question your lordship should ask is, what is the imperative necessity of throwing out this whole page? Because if your lordship really were to apply the true test, then your lordship should throw out this page. Reverse this page, overrule this page. Now see the next test. Alter ego piercing of corporate veil may be required. My lord has given reasons. My lord has had in 2, 3 and 5 years and given reasons. Now, unless something compellingly wrong is shown, then all this should be overruled. Then, engaged in negotiation of performance of the commercial contract. Well, actually what happens is, this answers both the shielding point and the wrongdoing point. Well, your lordship does look for the intent. Let me give a nuanced answer to the point. Of course, your lordship goes by intent. But intent is both a subjective and an objective test. It's not a subjective test where I tell your lordships, I know I'm fully involved in this contract, but I will create a structure whereby, despite my full involvement, I will say my intent is to shield myself from arbitration.
As one of the cases
That your lordship's objective test kicks in. Your lordship is the judge there.
subject, as one of the cases says, that it reduces the subjective intent of the parties from objective fact.
That's my next sentence. Therefore, the subjective intent test alone is constitutive of great injustice, and then your lordship must overrule the doctrine. What your lordship has never done is know or yes are black and white. My lordship has operated in the zone of grey. Otherwise, why do your lordship have these 15 principles, Manas? Because your lordship knows case by case justice can't be done without these 15 principles. Otherwise, lordship says, yes, we accept it fully or we don't accept it at all. No, your lordship says we accept it, but family-run companies through complex structure is one test. Yes, we accept it, but tight group structure with strong organizational financial links is another test. That is the right way to do it with respect, Manas, because your lordship will then be doing justice without straitjacketing it in an exhaustive manner for unknown speculative situations in the future, which your lordship can never predict. Lordships can never predict. Does your lordship want that injustice on a logical application of the other side's case? My respectful submission is answer has to be no. Yes, if your lordships can be pointed out any major fallacy or error in this page 6 principles I have given, then your lordships can tweak it. Has anybody told your lordship specifically in what language to tweak it? With great respect, I ask that question of myself. Not really. Either it's a throw the baby out of the bathwater or say it in a generalized way without telling us which principle is wrong here. And Manas, that subjective objective is very important for the Chief Justice also, Manas, Justice Narasimha. Manas, if your lordship were to give extreme and dispositive, conclusive weight to subjective intent, then Manas, really your lordship is saying every non-signatory is out. Because the intent of the non-signatory is not to be bound. Then why have a signatory, why have a doctrine at all? It is already that your lordship's objective intent kicks in and balances the subjective intent. But it has never been the absolute subjective intent. My lord applies the mind that objectively the whole system is there. Just because he has ring-fenced or created a structure, we will not leave our adjudicatory job of injecting some objective intent to do justice. That's the real crux of the matter. So, as I leave this page, my 2 or 3 takeaways, if I may use the word, is 1, would your lordships have any compelling need shown to your lordships by the other side to overrule this page? Is question number 1. The lordship has jurisprudence, the lordship has case law, the lordship has decisions. There must be something shown why the constitutional bench was. I'm not saying lordships can't do it, but really many or all of these should be overruled. And certainly, because I find the compelling need, if at all, is the opposite side, not this side. The second takeaway from this page is that, I'm sorry, my apologies. As well, and friend adds rightly, that to 10 years after chloro, as your lordship is celebrating the decade of chloro. So your lordship should overrule.
10 years after, but just a thought. I think we haven't yet come across a critical mass of contradictory views in the context of chloro control principle. It's perhaps a little too early. As you are saying, that there are no another set of cases which had proved to the court that this doctrine is excessively applied or overarched or wide enough, so much so that the court should take a step back and control. We haven't yet arrived at that situation, is what you're saying.
I'm extremely grateful, and may I, with your lordship permission, adopt that phrase, critical mass. That is the critical phrase. It is possible for a constitution bench which finds a predisposition of a mass of cases this way and that way, that is either equal or heavily weighted against the chloro doctrine. It is possible your lordship reaches a critical mass sometime in the future. Otherwise, really a constitution bench is being asked to do an extraordinary thing. And again, it is left unstated by them because they know if they put it like that, lordship would find it unpalatable. So it is not put like that.
To be fair, they have not put it at that level.
That's my problem. They have not put it, actually they mean that level. Exactly what my lord, that's my submission, your lord.
Right, you are saying that.
The consequence inevitable is that. That's the point.
But they have not brought forth, as Brother Narasimha said, the critical mass of evidence.
Let's just look at this critical mass phrase, very important phrase. Your lordship has got most of the cases actually on this chart. I mean, there will be 2 or 3 missing, but most are in this one page. Well, the interesting thing is that the critical mass is leaning in favor of chloro. So what is the Constitution being asked to do? It's asked to create a new status quo without showing that the existing status quo has run amok. Without demonstrating in any reasonable way that the existing status quo has run amok. For example, your Lordship has some judgments. I'll not name them as the old time, etc. I mean, one I can name as I argued Balco, private with Bhatia. The Lordship has evidence that international commerce was being affected. There's a whole UN cry. But chloro, these judgments have been controlled. They've been actually very calibrated, very careful, cautious. They've not gone overboard.
You get the point.
This is
What's
the second aspect is, come to my first note, section C. Well, let's just stop for 30 seconds on section B. I formulated the 2 issues. We must remember the origin. These are the only 2 issues. In my B.1, this is the first note, the opening note. I'll not read it, Lordship knows. This really should be a Lordship's broad guiding pole star, these 2 issues. And none are made out in favor of the other side. Whether the acceptance, etc. of the group doctrine by several religions is not permissible within the 4 corners of the 96 Act. That's a clear, good guideline to follow. And second is divorce above, whether you should. Original and rejoinder.
Yes.
The broad guideline. Now come to section C, category C, lower down that first note itself, first note, opening note. What are those 12 or 15 principles? I'll read a sentence each. It's the same chart, but put in the point of submissions, put in the form of submissions. So first is true and genuine effectuation of the real intent of parties. But real intent where it becomes a form of avoidance, no, then the objective test comes in. Suppose your Lordship were to find in a case that the real intent actually by performance, by context, by negotiation is not to be involved. Then your Lordship will say, no, there's no group doctrine. It's not bound by arbitration. Your Lordship is entitled to the existing law. What is wrong with that law? My Lord says enough tools not to punish an innocent party. Second, related part entities playing a predominant role both at the negotiation stage at the inception and in the performance. Now suppose, both these tests, this is an answer also to the subjective objective which my Lord Chief Justice formulated. Suppose your Lordship gives a finding of fact in not this case, actual case, that I am fully involved in negotiation, plus I am fully involved in performance. But because I am a foreigner, I have so designed it that I don't want to be caught in arbitration. Doesn't matter. Sorry, it doesn't matter. Your Lordship should be able to control that. Absence as a group doctrine would allow evasion and avoidance of legitimate collective responsibility. That's a consequence. I'll leave that. Hypothetical approach. I'll leave that. Now, certainly the Whale doctrine, even they have conceded. That's C.5. Even they are conceding in some form or the other. But certainly I am not agreeing that it is coincide with only the Whale doctrine. Rest of the seen a very, very important concept is C11. This is a judicial policy and a public policy. Not that any single swallow will make a summer. No single point is enough. But the totality your Lordship will see. In a genuine case where a Lordship gets a fragmentation, why should Lordship allow it? In effect, you are using it to stop what? Legitimate arbitration. Look at your Lordship's pro-arbitration approach in a whole set of jurisprudence. In effect, C11 means you are thwarting arbitration because you are fragmenting it. In effect, no effective decree is passed. Then I've given C9, which is composite and all that. Anyway, this is just to remind my lord that all of these principles are there. I'm not reading about them. There are about 12 or 14 of them. Well, there's a word here, and then I go back to my agenda note. C15 and C16 are more important than they are given the weight of. Claiming through or under in the law commission is not being given enough weight by the other side. If that is so, malus, then merely saying non-signatories will not, malus, nullify this. I've given various reasons for C15 and C16. That has not been answered, that has not been really dealt with. That, according to me, malus, I reiterate fully. The entirety of the law commission, the 2(1)H argument, section 8, I'm saving time, I'm not reading it, malus. That is an important consideration in a particular case. Now I come, malus, to my rejoinder note. I return to my rejoinder note. Very quickly, malus, I'll finish within time. First is, who is a party must be in accord and comply with principles of law of contract. That's the point. I'll not read the point, but I'll read his response. 72 of chloro in my CL1 provides for clear intent to bind signatory and non-signatory, cannot be restricted only to intention to consider peers for cooperative, alternative, tight group structure. Same point I made. Second point made is party autonomy. So the first point I really made, if Lordship appreciates what I'm saying, I'm not really reading it. First. Second is party autonomy. Kindly come to my response. It is essential to understand the true intent by way of their conduct. It is with a reliance solely on party autonomy would negate the doctrine. This Honorable Court in ONGC in para 40 has laid down the test. Mutual intention, relationship of a non-signatory, commonality of subject matter, composite nature, performance of contract. What's the point of ring fencing with 5 safeguards? If it is so simple. Well, as party autonomy, then all this is useless. I am non-signatory. Clearly, I know that. What's the point of all the launches? On the contrary, the launches is finding a way to effectuate it. And that's the right approach. Third, privity of contract. Same answer. These are all traditional doctrines. Law will not advance if you go back to privity. Because how many categories does the lordship have where privity is not sacrosanct? Does the lordship have less categories of privity not being sacrosanct? Whereas there is a book by Michael Atiyah, which I read in my student days, The Beginning of the End of Contractual Intent. This is written almost 70 years ago. English people who are conservative found the beginning of the end of contractual intent. And a lot of us today told party autonomy and contractual intent is conclusive and dispositive. Maybe one of the, how the same cannot be the sole basis. In fact, case of non-signatory, this court has used the doctrine of piercing a cooperative. Non-signatory may be held to be bound on a consensual theory, found on agency, assignment, non-consensual basis, estoppel, altering. The courts have added additional elements, common intention, negotiation. These are of course juristic principles by eminent authors and a lot of judgments which has adopted those authors. Carey-Bourne, etc. have given these theories. Then was whole. It's a repetition, really. With the para given of para 39 ONGC. Para 4 is that. Now this through or under is para 5. Through or under. Through or under relates to my first note C15 and C16. Just to cross-reference it once. My first note C15 and C16. In addition, it has been held in para 73 of chloro that a non-signatory could be subject to arbitration without their prior consent in exceptional cases. The court may lay down the parameters which permit play in the joints. The court will examine these exceptions of the custom of direct relationship of the party to the agreement, direct commonality, and agreement between the parties being a composite transaction. Then this US and Germany, I'm not spending time in para 6. We also will come to para 8. A point I have already made with us. Compelling reason, entrenched doctrine in Indian law. Compelling reason not shown to your lordship. An entrenched doctrine is para 8. Para 9 is about implied consent, a phrase which fell from your lordship, section 7. The above submissions cannot be accepted for the reasons A. Doctrine be applied in facts, etc. Each case cannot be a straitjacket formula. And if you also were to find adopt this all or nothing, then there will be no grey area. Lordships can't handle individual cases in future then. Well, GCD is a reasonable and a natural extension of piercing the veil doctrine. Some or all already established legal tests regarding piercing would be applicable depending on individual facts. Then, you have chosen a private forum is argument number 10. Parties have a right to choose the forum and the parties to the agreement, but circumstances arise where a non-signatory company can be roped into arbitration because the court found the existence, quote unquote, from MTNL. A tight group structure with strong organizational and financial links so as to constitute a single economic unit or a single economic reality. If your lordship comes to that factual conclusion in a case, why should the tyranny of an intention doctrine defeat this? Is my question to myself. Then 11. And for Mr. Advani, but I would beseech my lords to keep one thing in mind. Your lordship already has sufficient guidelines. Naturally, your lordships can tweak it in this way, that way, a little bit to make sure it's strengthened. But otherwise, there is nothing in this case in terms of either absolutist or completely. Otherwise, it would actually wreak havoc on what is now an established trend of law. That's a very deep.
Thanks.
Dr. Singhvi, amongst the multifold talents that you have, you also have the talent of lip reading. Lip reading.
Even if I did, I would not disclose. It's a very valuable talent so long as it's kept hidden.
That's a talent by itself.
I can assure lordships, I don't. I don't. And I'm glad to hear the subtext of what a lordship says seems to be in my favor, but I don't know. I'm never presumptuous about adjudication.
Singhvi, you may not want to
Because it's closed.
You may not want to reveal a bar secret, but I can tell you a secret which I picked up. I was sitting exactly where your junior is sitting, and where you are standing, Mr. Fali Nariman was leading me. That was the withdrawal of the prosecution of the Chief Minister's power under Section 321 of the CRPC.
Oh, yes.
Had come up and had been referred to a constitution bench presided over by Chief Justice Bhagwati.
Shivnandan Paswan was.
Right, Shivanandan.
I was on the opposite side.
Recently Supreme
I
Court.
was on the opposite side.
And, that was where Justice Bharuli.
3-2. Justice Venkataraman, 3-2.
That's right. They ultimately, the matter went 3-2 in the Constitution.
That's right, 3-2.
So the judges were conversing, and I was briefing sitting by the senior Mr. Nariman. And I thought that I'll use the time, to tell him what our next line of authority was going to be. So he turns to me and says, never speak when the judges are speaking. So I said, sorry, Mr. When we left the court at 4 o'clock, he says, that's when you get to know the mind of the judges. Something which has not left me, learning lessons from the greats of the bar.
I shall pay more attention to this very wise advice.
We are now inventing how to read the minds of lawyers while sitting here.
I believe that.
Deeply obliged.
Very deeply obliged. Your Lordships know what happens when we are on this side.
Yes.
Look, I'll just take about a minute and a half, 10-15 seconds for me
never
to
forgot.
respond to what Ms. Arora said.
Yeah.
1 minute, minutes to respond. As far as the submission which Ms. Arora had made, there's just one aspect I want to point out. That while it is a section 9, the entire determination which your Lordships will see at paragraph 6, 7 and 12 of the judgment was only on the proof of companies doctrine. So as far as the issue is concerned, the issue is in fact the identical issue that your Lordships is hearing in 501. So it shouldn't be delinked in any form. That's the only one point I want to make. There's just one thing that fell from my Lord Justice Narasimha, which is in relation to has the critical mass of cases been brought before my laws to say there's some kind of abuse or not. Because I think there are two ways to look at this point. The first way, my lords, is which are the two countries we are akin with, at least as far as adoption of the model law is concerned, and one of the localized theory, England and Singapore. And both those countries have rejected the doctrine, we have not. So are you really consistent with two other countries which follow us the same meters? My respectful submission is no, that's one part of the critical mass. Look, I don't want to give you evidence at the bar, but I can tell your Lordships that there are at least 15 or 20 cases where I have been involved with, international, domestic, where these issues crop up very, very often. Now, obviously, they're not there before my lords because if a section 16 gets dismissed and jurisdiction is upheld, because awards take time to come, 34s are challenged, the issues may not be there before. But there are a number of these issues, and therefore, when your Lordships is considering it, all I am requesting for is bringing about a level of certainty. Now, why would I not apply this if I was in Singapore and London? I wouldn't apply it there because if a group structure is brought, party takes a simpler route. It goes to the English Commercial Court or it goes to the Singapore International Commercial Court or it goes to the Singapore High Court and says, I don't need to go to arbitration. I have a great commercial remedy. I go to court, I get the injunction. I get a trial disposed of within 2 years, 3 years, and that's the end of the matter. We have a commercial court structure here. And that's really,
let's give 5 minutes to Mr. Advani.
I'm just grateful for a very patient hearing. And I must just point out to my lords one very interesting aspect. It's a very personal aspect. The first time I appeared before a CB was in 2012 in the Balco case. When I appeared for the Singapore International Arbitration Center, which had filed an intervention application. And I got my 7.5 minutes on that side of the table, right towards the end. Look, this is in fact, from an arbitration perspective, the second time, I've appeared before other CVs, over that 10, 12-year period. But from an arbitration perspective, this is the second time I've actually addressed a CB on
Thank you, Mr. Thank you.
And I'm deeply grateful for a very brief.
Thank you, Dr. Singhvi. Yes,
I just want to present a slightly different perspective. I'm not going through any case law, your Lordship has heard it all, but all institutions all over the world, and I have been part of two of them, the Singapore Arbitration Center and the Dubai Arbitration Center, the appointment of arbitrators is done by the institution. It is not a big judicial exercise. They are prima facie appointed, and then the arbitrators go into the issues, whether the group company doctrine or any other theories that are there when non-signatories can be joined, and based on the facts, they make the decision. And now here also under our section 11 has been amended. It has not come into effect, but I'm told it's very close to coming into effect. The draft rules of the institutions have been published and that process is on. Ultimately, it will be the institutions doing this role that your lordships are doing today. So if your lordships leave the issues open as widely as possible for every conceivable issue where the arbitrator thinks it's appropriate to join a non-signatory, let him take the decision. There may be 7 different theories. Why does your lordship confine them? After all, if your lordship recollects, the whole group concept concept of group companies has come from where? From Dow Chemicals. It's come from an award. It's not come from a court decision. And since now we're also going toward the appointment of arbitrators by the institutions appoint only prima facie. Arbitrators will come to finding the fact one way or the other and decide this issue. And we've also done arbitrations all over the globe. The arbitrators have considered it sensibly and joined or refused to join party. This is happening consistently all over the globe. Why are we taking a restrictive view to this? Let's keep all the judgments are in place. They're well reasoned. Why do they need to be tinkered with? We have a stable body of judgments. Let the arbitrators follow them, whichever route they think is appropriate. They'll either agree, they'll join the party, or they won't join. Why do we do a narrowing exercise? Let the exercise be as broad as possible. And if an arbitrator goes too much out of line, the courts are there to correct him in a 34 application. So lordships will keep the judgments exactly as they are. The points raised in Justice Ramana's judgment were already answered by Justice Suryakant's judgment. There are several different tests. Why does your lordship want to narrow them? Let the arbitrator apply it depending on the facts of each case. And sooner or later, this is going to be an institutional exercise, not a court exercise. So let's leave it as wide as possible. Let's leave the arbitrators ample room to take decisions. And if they go so wrong, the courts will correct them. And that was just a perspective I wanted to give your lordships. I'm obliged.
Thank you, Mr. Bani. Thank you very much. So we'll
I just had a small request to make.
conclude judgment reserved. Yes.
I just had a small request to make, Milad. We had also intervened IA 58750 of 2023. May I have your lordship's leave? We'll put in written submissions. I want to prune it down in view of what has transpired.
Not more than 2 pages.
Absolutely, Milad. We'll try to keep it short. Grateful, Milad.
Thank you. Thank you. Thank you. be difficult to argue one by one.
I agree.
Both at a time.
Malas, posterity will also get to know what foolish arguments we made, Malas.
Also good arguments.
But nobody admits, nobody admits.
But it's we will, of course, this will be a great record for the court.
Yes, yes. No, I think it's a wonderful idea.
Truly a court of record.
Yes.
Because every word is recorded.
It should be. It should be.
Every word is recorded.
Court of record.
Malas, in fact, I can share something with you. When Malas practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about this, about the 70s. Malas, they would record everything that was said in the course of that examination, even then. So that we know, lawyers knew what was going to happen.
Gujarat has e-court in the sessions division, where even our internal whisperings are also recorded.
That's very dangerous.
Use it.
That's hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem, but they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So
That's wonderful. That's wonderful. That's truly
In VC
truly
proceedings,
a milestone, I would say, Malas.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that setting so that it won't
Hopefully.
overlap with one another.
So, Malas, let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
pen drive last time ka. Yes.
what is in issue is whether
Last time ka.
the legislative party, that's the central issue, whether the legislative party in the House acts independently of the political party. That's the central issue. Because I will, Malas, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which, Malas, some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the, don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malas, there is an umbilical cord link between them while they are sitting in the House and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malas, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Well, the bill is introduced by the Treasury benches, any bill.
So
What
is it
happens?
your contention, therefore, is it your contention, Mr. Sibyl, therefore, that unless there is a split outside the House,
Yes.
within the political party,
Yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention.
It could
That's the law also, Mullah, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Mullah, I'm giving your lordships an example, Mullah. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Mullah, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Mullah, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now, there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Mullah. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Mullah, there's a problem. Supposing, all right, then let's analyze that for a minute, Mullah, since your lordships have raised the issue. Mullah, supposing there are 10 members of the legislative party in the House, right? And the merger has to take place of the political party. They belong, say, to the Mullahs, to the Samajwadi Party, right, Mullah? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore, Samajwadi Party has to merge.
But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the Speaker cannot take a decision within the House, within
No,
his
Election
constitutional
Commission
remit
did
on
not
whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Mullah.
How else?
Because a resolution will be passed that we have merged, and that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
Not so.
Let's have a broad now framework of the facts, because
I will, Manoj.
in fact, that was our basic problem there. Unless we have a clear perception on the
I'm going
facts,
to
it's
do
very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, Manoj, may I just, your lordship, what are the issues that are going to be? I just told your
that's
lordships too.
we have to necessarily reframe the issues, because the issues which are there, which are
Yeah, it's not reflective of, Manoj, what needs to be decided. I agree entirely. Manoj, the other issue is, and that's never come up before the court, and that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows it. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that, because they happen to be majority in the legislature. Well, that's one of the issues that your lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. That's correct. Because under the 10th schedule, it has the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the powers of the Election Commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Mullahs, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibyl, is your independent challenge to the order of the Election Commission.
That's a separate issue, Mullahs.
We can't really decide.
No, that's part of the reference, Mullahs. I'm going to argue, Mullahs.
Can we, how do we...
He's saying...
Constitutionally, the Election Commission cannot proceed. Mullahs, the split would have to happen on 21st of June. There was no whisper.
Your contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what your lordship said. No stay, fine, Mullahs, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Mullahs, when your lordships sit at 3:30. But be that as it may, that's the last question that your lordships, your ladyship will have to look at. So these broadly, Mullahs, are the issues that you might be asked upon to decide, Mullahs, that you might wish to decide. Now, my lords, let's go to the list of dates, because unless you have the facts, my lords, it will be. My lords, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learned how to use the iPad.
Mr. Sybil, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to give
Yeah, I think it's a good idea.
call before we proceed further?
Yes, reference order. Your lordships will have that. Order compilation, my lords. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, my lords, 23rd of August, 2022.
Page 28.
Page 28, my lords, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, my lords.
28.
Your ladyship has it? Justice Shah, my lords?
Yes.
May I, my lord? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Well, I've already argued that. So lordships, my lords, have deferred your lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the speaker? Actually, B and C are together, my lords. They are interlinked.
Per se cases.
Yes. The language is somewhat, my lords. D, my lords, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? My lords, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, my lords, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, my lords, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then, my lords, what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic tradition, that you should await your hands till the disqualification is decided. First, because this problem will not arise then. Then, my lords, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party is referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Mullahs, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government and whether the same is amenable to judicial review? Well, it's governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Mullahs, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Mullahs, in the early hours of the morning, gave an oath, to the oath of office, Mullahs, made somebody a chief minister, and by the early morning, Mullahs, on daylight, he had to resign. governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Mala, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Mala, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
That is A, right? A, petitioner written submission.
10, yes, A. PDF 108.
Written submissions of the petitioner.
Written submissions, no?
Yes.
You are referring to written?
Yes.
Not additional written submissions. Not additional written submissions.
A, madam. A. Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. And we can have their feedback so that we narrow it down to certain specific issues. The issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I said that
let's
already.
sort of structure that so that it lends some clarity to.
Well, let us do that in the evening. Well, that'd be much easier for us.
Difficulty.
If your lordships will allow us, because I'll consult my colleagues.
Yes,
We'll give some agreed issues,
in the evening and give us some agreed issues which will arise.
Because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take, so that then we can restrict them as well and to certain time.
This side, Malaz, will take 3 days, Malaz.
Mr. Sibal, how long would you take? About 3 hours or so today?
No, Malaz, I'll take much more tomorrow too.
Sibal, we'll have to have structured arguments.
All right, it'll be structured, Malaz. I'm not going to repeat myself at all. Your lordship knows I myself, Malaz, reduced,
After Mr. Sibal, after you conclude, Dr. Singhvi will
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give doctors lunch tomorrow.
Yes.
And then a little supplement, half an hour after lunch for Mr. Kamath. And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude maybe lunch. And then we give you.
We'll try that, Manoj. We'll try that. No issue, Manoj. We'll certainly try and speed it up. I mean, I just think, Manoj, your lordships may have questions yourselves.
No, of course. If we find that, of course, there's a little change in the time schedule, we can certainly.
Then, Manoj, your lordships will also have to decide on the Nabam reference at some stage, what your lordship wants to do, because that sort of opens up another.
So we'll look at the list of dates?
Yes, Manoj. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to the legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, Malad, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party, was omitted. Available as a defense against disqualification under the 10th schedule. Malad, please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It was not a split of the legislative party. Paragraph 3, and I'll read that to your lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to your lordships, now there's no question of majority, minority, 1/3, 2/3, no, not relevant. If there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, Malats, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordship, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, Malats, October 2019 elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, Malats, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Agadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, mullahs, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November?
Yes.
Supreme Court's order?
Yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then this mentioned, anyway. April, May 2020, governor has been at loggerheads with the MP. 25/11. Oh, 25/11, Sunil Prabhu. Now this is important. 25/11, Sunil Prabhu is appointed as chief whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship, may actually, if Your Lordships don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thakeray's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for in the Legislative Council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has along with certain others delinquent MLAs of the Shiv Sena gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21(6), these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your lordships has to consider. So a faction which is a legislative party decides that I will change the whip. Constitutionally impermissible. Then, Millards, the decision, then Millards, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, Millards, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, Millards, in the meantime, somebody had to be appointed, Millards, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, Millards, the legislative party or a majority of the legislative party can decide who's going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. Our legislative party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM Malaz is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. June 23rd, Sir Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly Disqualification on Ground of Defection Rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June 2022. On 25th of June, the National Executive Meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of his original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the legislative party to submit their written submissions up to today, today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here, as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. Nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed on a disqualification petition that no. If a petition is filed, you can file your reply after 10-15 days. In the meantime, the minority with the other party topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced, This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shiv Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide, given these facts? Then 28th of June, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June, to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this honorable court seeking a stay. So, as we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given our thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the Deputy Speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceeding of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing, brothers. Proceeding of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, my lords, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality, because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned, because he knows the writing was on the wall, having given legitimacy to those who... Then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in, in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malaks, one second. Yeah, I'll take it. Then, Malaks, 1st of July, 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Samant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10 scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So, this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as chief whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as chief whip of SSLP, issued whip to the members of SSLP regarding the election of the speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip? And vote for a BJP candidate against the Shiv Sena member? There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. On the evening of the 3rd, after
how many votes the rival candidate polled that day?
Sorry?
July. How many did they poll on the 3rd of July? Speaker.
That's all. We are not millers on majority minority. Yes, that's correct. I'm glad that my friend pointed it out, Millers. Correct.
But therefore, if these 34, they still have 125.
I am not Millers on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, Millers. I'm not saying, Millers, whether he would have. Supposing, Millers, all of them are disqualified because they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
yes,
from the 164,
yes,
they're still down to, they still get 125, right?
That's right.
Your Lordship is right, Millers. At the moment, Millers, I am not challenging. At the moment, Millers.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
The trust vote happened on the 4th.
Because, Mr. Sibal, you don't
happen on the 30th, Millers.
Right. You don't, ultimately, you don't face the trust vote.
Yeah, I don't, Millers. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the Speaker, trust vote, whatever. All that is challenged. At the moment, Millers, we are dealing with a very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, Millers? These people were able to topple the government without the disqualification petitions having been decided. There was an elected government, Millers, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, Millers, your Lordship holds by these actions, which are uncontroverted, that they disqualify themselves on both counts, 21A and 21B, what will be the result? And if your Lordship holds otherwise, let's assume, against me, then this will be, Millers, You have given them a model to topple every elected government.
Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held on the 30th.
Yes.
Now, you resign, right, on the 30th.
Yes.
And therefore, is this not really clearly an indicator that even excluding these 39?
That's all right. The speaker could have been Manoj. Yes, I'm not disputing that, Manoj. I'm not sure what the arithmetic is.
Manoj, what my Lord
Half 145 is the halfway mark, Manoj.
Manoj, what my Lord the Chief Justice
You
asked.
deduct 34, you are below, Manoj. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord, 288 was the total.
Yeah, just the number. Just give it.
We'll just give you the
Strength of the assembly. The actual.
Just 1 second.
Yes.
Total strength of the assembly
200
from Mr. Sibal's chart, which we have.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second, just one second. Total strength
So
of the
the half
assembly.
mark would be 145.
Just
1 second.
Yes.
164.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those,
Just 1 second.
249, half of it is
249 and then.
and the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed.
Plus, there were only 16 disqualifications.
Yes. Plus on that.